Through 4 trials of Baltimore police officers charged in the arrest and death of Freddie Gray, one thing remained constant. Circuit Judge Barry G. Williams often called the prosecutors and defense attorneys in the trials up to his bench so that they could discuss issues of testimony or evidence without being heard by those in the courtroom. In Maryland, such bench conferences are kept private through the conclusion of the proceedings. In this case, the judge kept those bench conferences private through the end of all of the officers' cases, but with 3 acquittals of 3 officers and the prosecution deciding to drop the charges against the 3 remaining officers, those bench conferences are now coming to light. What we've been able to glean from those conferences is that there was often banter back and forth between the judge and the prosecutors and the defense attorneys. There was also quite a bit of bickering about what evidence could come in at trial, what sort of questions could be asked of witnesses on the witness stand. At one point, for instance, they argued over whether or not the defense attorneys would have access to emails and other documents from within the prosecutor's office that had been created prior to Baltimore State's Attorney Marilyn Mosby announcing the charges against the officers on May 1st of 2015. The prosecutors in court argued that as work product of their own, it was not subject to review by the defense attorneys. The judge said that that was not the case. He agreed with the defense attorneys that the prosecutors had put themselves out to the public as investigators themselves in the matter, and that they couldn't have it both ways. He therefore ordered that the defense attorneys have access to those emails. There are a lot of little issues and larger issues that were decided during bench conferences, and we were not privy to those conversations until now. You can read more at baltimoresun.com.